While today ends this year's term, the court agreed to hear one case from North Carolina for next term that could have potentially cataclysmic repercussions. The Washington Post writes, quote, the Supreme Court on Thursday said it will consider what would be a radical change in the way federal elections are conducted, giving state legislatures sole authority to set the rules for contests, even if their actions violated state constitutions and resulted in extreme partisan gerrymandering for congressional seats. Even if their actions violated state constitutions. This case is about North Carolina, but if the conservative justices rule in favor of the Republicans, it could have an outsized impact because Republicans control both houses of state legislatures in 30 states. Joining us now is Dahlia Lithwick, senior editor and legal correspondent for Slate.com. Dahlia, good to see you. Thanks for making time for us tonight. What was your reaction when you learned that the court would be taking up this case from North Carolina about state legislatures having absolute power over elections and that courts can't get involved in decisions made by the legislature, even if those decisions seem to be counter to the Constitution?
Yeah, this was the thermonuclear option. This was the thing we've all been waiting to see if the court was going to take up. And I think you've described it perfectly. I mean, this was more or less the theory that was being pushed by John Eastman and Jeffrey Clark and the folks who were asking to set aside the results of the 2020 election. So the idea that the court is now agreeing to take it up in advance of the 2024 election. We know, by the way, that there's already 4 justices who have signaled in various cases that have come before it. There's already 4 justices who are kind of on board with this. So the idea that the court is teeing this up in advance of 2024 is pretty bone-chilling.
Let's talk about this for a second. The idea is that the courts are there, if they're operating properly, to have a check on when there's legislation that is challenged because it is deemed to be unconstitutional. What's the logic behind a case like this? What's the logic behind saying the courts can't have a role even if the states do something that's wrong?
I think you're making the mistake of trying to find logic. This is a profound misreading of, an opinion in Bush v. Gore that only garnered 3 votes. It's a profound misreading of the word legislature. This is another one of those ideas that kind of comes up from the bowels of the kind of far, far, far reaches of the conservative legal movement. It has no actual salience. It's just really, I think, a totally instrumental way to give state legislatures the power to override the judiciary. And I think that, we can talk for hours and hours about what the word legislature means in this construction. But the truth is, it's just another one of those theories that didn't exist until it did. And now, evidently, it does.
You wrote in Slate in your latest piece about the court this term, and you said that, quote, those arguing the brand new jurisprudence emerging this week is markedly more cruel, more overtly theological, and more contemptuous of the regulatory state are all correct. Talk to me about what you meant by that.
This term has been like nothing I have ever seen and nothing that most court watchers have ever seen. It has been both a kind of ends-driven, maximalist, swing for the fences, go for broke on everything kind of term. And I've been thinking about this a lot in the last week, and it occurs to me that we've been so institutionalized that we tend to say, oh, there's a new test for gun regulations. They built a new test. There's a new test for abortion regulations. They built a new test. There's a new test for church-state separation. They built a new test. Today, they built a new test, this weird major questions doctrine that is going to be going forward how we think about regulatory agencies. And we make the mistake of sicking con law professors on this as though there's a new test today. There's no new test. The test is whatever the court wants. The police always wins. The religion always wins. Women always lose. The condemned always die. And I think we're just making a mistake of treating this like doctrine. It's not doctrine. It's just a checklist of what this conservative legal movement has always wanted.